you for joining me as I evaluate CISO personal liability, examining SolarWinds case and its implications for the profession. By personal liability, I define it as civil and criminal exposure for individuals beyond corporate penalties. Here's the agenda. First, a thorough review of SolarWinds case. Second, arguments for and against imposing personal liability on CISOs. And lastly, my personal opinion. These are three of the most notable cases where cybersecurity leaders were individually charged for personal liability. The first two committed fraud and faced criminal charges. Tim Brown's case is different. It was the first time the SEC charged the CISO individually for misrepresentation in public disclosures, a civil, not criminal charge. And the first time regulators used securities disclosure theories to target someone acting as a CISO. That's why this project focuses on SolarWinds. SolarWinds is an IT infrastructure management company founded in 1999. It was publicly traded from 2009 through 2016 and again from 2018 through 2025. This timeline matters because public companies must disclose material facts under federal securities laws, and that was the main grounds for the SEC's charges in 2023. Tim Brown joined right before the second IPO in 2018. In December 2020, Sunburst was discovered. Malicious code hidden inside legitimate Orion software updates that customers trusted and installed. Orion was the company's crown jewel, accounting for over 45% of revenue. And at the time, SolarWinds had a large customer base that included nearly all of Fortune 500 and major federal agencies, including Treasury, Homeland Security, and even the National Nuclear Security Administration. The attackers were Russian state-sponsored, and they had stolen 7 million emails from SolarWinds employees and various data from its customers. The SEC's investigation led to civil charges in October 2023 against both SolarWinds and Tim Brown individually. SEC's central claim was that SolarWinds and Tim Brown made materially false statements across three types of public disclosures. First, the security statement, a public document on SolarWinds' website claiming they followed NIST, enforced strong password policies, controlled access on a least privileged basis, and maintained a secure development lifecycle. Brown owned and approved it. His photo was on the Trust Center page, and it was regularly shared with prospective customers. But internal documents contradicted every claim. NIST, only 6% of controls were met. Passwords, their server password was SolarWinds123 and it was discoverable online. Access controls, there are internal presentations where Brown calls out access control issues himself. SDL, acknowledged internally as false since 2018 and never corrected. Internal red flags were accumulating, and despite so, the security statement continued to remain positive and unchanged. That gap between what was said publicly and what was documented internally is the foundation of the SEC's case. Second, SEC filings. The S1 and S8 forms used generic copy-pasted risk language across 13 filings, warning of potential harm if a cyber attack occurred. Even as internal red flags accumulated and Brown was writing internally that the company was in a very vulnerable state. Third allegation, the 8K filed after Sunburst was misleading. It used the language could potentially allow and investigating further, but the SEC claims Brown had already linked the malware to prior attacks against a government agency and a cybersecurity firm. In all three, the SEC's theory rests on a gap between public disclosures and internal reality. And next, let's look at the evidence. SEC reviewed 3 years of internal emails, messages, and presentations, and they paint a picture of an organization that knew its public statements didn't match reality and chose not to correct them. Top left, in this email, Tim Brown acknowledges they weren't actually doing some of the things described in the security statement, including secure development lifecycle. Rather than update the statement, the response was to begin working towards making it true. Left middle, a conversation between an employee and a manager regarding the fact their Orion software has too many vulnerabilities for them to be able to fix anytime soon. There were presentations where Tim Brown highlights issues and vulnerabilities to his leadership team. So the SEC again interpreted this as a gap because the public disclosures remained unchanged. And the last example, when a cybersecurity firm asked SolarWinds whether they'd seen similar attack behavior before, an employee said no, then messaged a colleague, well, I just lied. Throughout all of this, the security statement remained unchanged. The SEC filings kept affirming accuracy, and known risks were never disclosed. What does it make you feel when you see these examples? So, what happened? After seeing that evidence, you might be surprised to see the headline here. Yes, the case was largely dismissed in 2024 and only one claim survived. For SEC filings, the court ruled that generic isn't the same as fraudulent. The law doesn't require maximum specificity, and in fact, over-specifying could backfire by giving attackers a roadmap. For the 8K, the court found no internal documents confirming SolarWinds had definitively linked the pre-sunburst incidents. No documentation of that link, no signature for that claim. And Brown's own habit of openly documenting deficiencies with leadership worked in his favor. The court reasoned that someone deliberately concealing risks doesn't openly discuss them with executives. The absence of document as evidence defeated the 8K claim, and Brown's candid internal documentation habit defeated the personal concealment argument. The accounting controls claim, this was the first time the SEC applied financial accounting statute to cybersecurity, and this was dismissed as well. Accounting means financial accounting, and the statute wasn't written for this purpose. Lastly, the security statement. This is the only claim that survived as the judge dismissed the rest of the claims. On this matter, the judge actually agreed with the SEC. The security statement was materially misleading across all areas the SEC challenged. And Brown's scienter was easily established in this claim precisely because he was the named owner and approver of the statement, and because internal documents showed he knew about the misrepresentations and let it stand for years anyway. The court called his conduct highly unreasonable. Okay, so what happens to the surviving claim? SEC had them, then let go. The case was fully dismissed in November 2025, with prejudice meaning permanently closed, no penalties, no admission of wrongdoing. Here's my speculation. The partial dismissal was in July 2024 under Biden administration. January 2025, administration changed. A new enforcement director for the SEC was appointed September 2025. Shortly after, in November 2025, the SEC announced it was voluntarily dismissing its case against SolarWinds and Tim Brown. And they were dropping other high profile cases too. Coinbase, Binance, and Gemini. In the dismissal statement, the SEC gave no explanation beyond the fact that they are acting in the exercise of its discretion and noting the decision does not necessarily reflect the Commission's position on any other case. What are the takeaways? First, enforcement strategy is openly uncertain. This specific case is closed, but the legal theories remain available. In the dismissal language, the SEC reserved the rights to try its legal theories again in other cases in the future. Second, The legal precedent from the security statement claim still stands. The court's reasoning on the security statement will inform future cases even without a final judgment behind it. And as a result, third, public facing security statements are permanently high risk. That materiality standard confirmed in this case doesn't change with administrations. And fourth, the candid documentation paradox remains unresolved. Brown's honest internal records were used as evidence against him. That tension has not gone away. We've built the context, the breach, the evidence, the case, and the dismissal. As a recap, these are the three main grounds on which the SEC argued the CISO should be personally liable: the public statements he authored, the certifications he signed, and the internal knowledge he had but didn't disclose. Which brings us to the central question. In the next few slides, I'll examine both sides for evaluation and I'll share my own opinion at the end. My answer up front: it's not a clean yes or no. The evidence doesn't support only one side. The case for personal liability. The Disaster Recovery Journal captures the core motivation. Legislators and regulators have watched high profile breaches cause serious harm with very little change in corporate behavior. The conclusion many have reached is that without personal stakes, companies won't take security seriously enough. First, fining companies alone doesn't change executive behavior. When penalties land on the company, shareholders absorb the cost, not the decision maker. A 2025 Fastly survey found 93% of organizations changed policies in response to personal liability concerns, including 41% elevating CISOs to board level decisions. The threat alone produced change, and it's a positive early sign. More CISOs have a seat at the decision making table. Second, investors can't evaluate risk without honest disclosure. SolarWinds stock dropped 35% when the truth about Sunburst became public. Investors had been making decisions on a false picture for 2 years, and personal liability is the mechanism that makes honest disclosure a rational choice. Third, Brown wasn't just an employee. He was the named owner of the security statement, and when you personally certify a public claim, accountability follows logically. Fourth, CEOs, CFOs, auditors, lawyers all face personal liability for their certifications. CISOs should be no different. The case against. Tim Brown said it well in 2024. When you don't have rules to follow, it's very hard to follow them. You just have to tell us what's right in order to do it. So first, the CISO role lacks standardized definition and scope. There's no universal standard for what a CISO is responsible for. Yes, in hindsight, it makes sense that public disclosures need to match the internal state of being. But then over-specifying risks could actually backfire. So there is a fine line between sharing too much and keeping things generic. Imposing personal liability on a role whose boundaries are undefined is legally arbitrary. Second, no organization can achieve perfect security, and personal liability risks punishing an unavoidable gap that will always exist. Third, yes, in theory, Brown could have refused to sign. In practice, CISOs who push back against boards and CEOs risk losing their jobs. And that is not a meaningful form of authority. Authority must be structural, not theoretical. If the enterprise won't do what the CISO says needs done, the CISO shouldn't be held liable personally either. Fourth, the chilling effect. Tim Brown and his colleagues had to question themselves while they were going through the hack. Can I expose this deficiency? Can I work on this thing that needs to get improved? How do I say this the right way that doesn't make me liable? Tim Brown said, That's 20% of my brain for a period of time got spent on thinking about liability as opposed to thinking about protecting the company. If honest documentation becomes liability evidence, CISOs will stop writing it, and organizations will shift toward vague, generic disclosures that tell investors nothing meaningful. Fifth, enforcement is politically contingent. SolarWinds shows enforcement outcomes can shift with elections. A strategy whose effectiveness depends on which party is in power is not structurally reliable. And without codified standards and protections, personal liability risk may drive experienced talent out of a profession when the industry continues to have a high demand for talent. Compelling argument on both sides, which is why my answer is conditional. This is my personal opinion slide, and again, my answer to the central question is not yes or no, it's conditional. The SolarWinds case was an effective signal. It sent a clear message about what the SEC expects and want to see. The Fastly data backs this up. Behavioral change happened without a single conviction. But the security statement was the only defensible ground. The broader theories were all dismissed, and even the surviving claim was dropped without explanation, likely for political reasons. This is evidence in itself that personal liability, as currently structured, is not a durable regulatory strategy. So, beyond SolarWinds, my personal opinion is that personal liability is not the most effective strategy in current reality. Tim Brown's case sent a signal, but signals through litigation are not sustainable standards. Finance has GAAP, law has bar rules. There's a clearly defined standard, and following it provides protection. Security has nothing equivalent. So I think it's fair that the case was dismissed. It was the first of its kind, and the expectations had not been clear enough. A codified standard must come before personal liability becomes the norm. And if a CISO is to bear personal legal risk, they must be a real decision maker, not just an advisor. Brown repeatedly escalated vulnerabilities to leadership. The failure to act organizationally should not be his personal liability. The accountability should be distributed, not concentrated on one person. So rather than rejecting personal liability outright, I propose three minimum conditions that must be met for the personal liability measure to be fair and effective. Conclusion. Personal liability for CISOs can be justified, but only when three conditions are met. First, clear evidence of intentional misrepresentation. Second, authority to match accountability. And third, a codified enforcement standard consistently applied across administrations. These three conditions are interdependent. Conditions 2 and 3 are necessary in order to fairly establish condition 1. Yet, in extreme cases, a sufficiently documented scheme might justify action even without all three conditions are perfectly met. But might justify is not the same as fair and durable. Applied to SolarWinds, the case fails on conditions 2 and 3 structurally. On condition 1, Scienter survived for the security statement. But because not all three conditions are met, I support the full dismissal. I'll close with Tim Brown's own words, spoken while he was still a defendant. It's not so much about reducing the liability for the CISO community. It's about how do we make sure that the things we have in place allow us to do our job in the most effective way possible without the disruption of legal or regulatory actions. The SolarWinds case sent a signal that the industry heard, and the behavioral change that followed shows it was effective. We'll see more cases. When those cases come out, I would ask three questions. Was there intentional misrepresentation? Did the CISO have the authority to match their accountability? And is the enforcement standard codified or does it depend on who is in power? Those three questions are my measuring stick. Personal liability is a tool, and its effectiveness depends entirely on how precisely it is applied. Thank you.